A very warm welcome to you all for the 41st seminar of the International PhD in Progress Seminar Series, organized by the Global South Network. I would like to start the session by thanking the organizer of this weekly seminar series, Dr. Numan Riyad, lecturer in law, Leicester Law School, the founder and convener of the Global South Network. My name is Patrick Masiyakurima. I work for City University London. I will be chairing today's session. My former colleague, Dr. Samantha, is the discussant for today's session. He is an associate professor at the Leicester Law School, and his research interests lie in the fields of company law, widely defined, and corporate governance. He investigates changes in company law which may impact financial growth, and his research uses various quantitative methods, and he also explores fintech and behavioral finance. Our PA commentator is Gabriel Emeasoba. He is a PhD student at the University of Aberdeen, and he is also a graduate of the University of Lagos. He was called to the Nigerian bar, and he worked as a lawyer in a Nigerian firm, and he did his LLM at the University of Aberdeen too. He is focusing on developing legal standards for electronic trade and trade finance, with a special focus on electronic letters of credit and electronic trade documents. Of course, we have our guest speaker, who is Rafaella Ethelonti. She is a doctoral researcher at the Leicester Law School. She is also an officer at the Commissioner for Administration and the Protection of Human Rights in Cyprus. We are very grateful to Rafaella for taking time from her busy schedule to share her project with us. Rafaella will present her project titled The Nature of the Payment Obligation of Banks in relation to trade finance transactions governed by Anglo-American jurisdictions. Rafaella, despite the initial hiccup, you have 30 to 35 minutes for the presentation, which will be followed by 5 minutes for comments or questions of the discussant and peer commentator. And then there will be 15 minutes of questions and answers by other attendees. The floor is now yours. Thank you.
Thank you. Thank you very much. I'm very happy to see all of you here. Today, I will try to present one of the initial topics of my entire research project, which is the exceptions to the payment obligation of banks in relation to trade finance transactions covered by Anglo-American jurisdictions. Today's topic will be restricted to the nature of this payment obligation. So starting with the research question, the overarching aim of the research is to explore and address the question of whether the well-established and long-standing principle of autonomy, which will be examined in a while, governing the various instruments which finance an international trade transaction, such as letters of credit, which are the instruments I will more engage with throughout my research project, may be pierced under certain circumstances which legitimate, justify disregarding the principle of autonomy and challenging, therefore, or jeopardizing even the payment, which is the ultimate purpose for which letters of credit are employed. So the main research question will be addressed based on doctrinal methodologies, which will be analyzed in this presentation later on. So the circumstances which I have just referred to as potentially allowing the principle of autonomy to be disregarded constitute actually an exception to the obligation of the banks to effect payment. based on the autonomy principle I have just referred to, which limits the payment obligation on the terms of the credit and prohibits any external facts or factors from being involved in the assessment of whether payment shall be honored or not. The exceptions which I am dealing with throughout the entire research project will be fraud, nullity, illegality, and unconscionability. Of course, there are cases where payment is prohibited, not as a result of these exceptions or the recognition or the welcoming of such exceptions to the various jurisdictions I will be concerned with, which is actually the main thing of my project, but as a result of the non-conformity of documents tendered for payment with the terms of the credit, or even as a result of an injunction being granted by the court in favor of one of the parties, usually the innocent applicant, not always, prohibiting the bank from proceeding with the requested payment in order to protect one of the parties from the other. For in the example I used, from the unscrupulous beneficiary. So injunctions will constitute a whole chapter of my project and will be extensively discussed. So moving to the significance of this piece of research, it has to be said that in order to examine the functionality of the already mentioned exceptions to the payment obligation of banks, which is the main topic of my PhD thesis, we firstly need to understand the nature of such and the context of such payment obligation on the part of the bank. The context and the substance of the undertaking of the bank to pay depends on principles such as autonomy and on sources of law such as case law, common law principles and requirements, standard banking practices and customs, or codes issued by professional banking bodies or trade organizations such as the ICC, the International Chamber of Commerce. And all of these are collectively forming the nature of the basis of the nature of the obligation undertaken by the bank to honor the payment after receiving a complying presentation. So having already talked about this crucial principle underpinning the entire operation of documentary credits, and the principle which is the cornerstone of the entire functioning of letters of credit, especially, it is important to devote a minute for explaining that according to it, any payment due under a letter of credit shall be exclusively made subject to the conditions of the credit itself and shall not be dependent upon the discharge of any other obligations agreed between the parties or any obligations arising from even the underlying sales contract for which the relevant letter of credit has been opened. So that's the cardinal rule of documentary credits, namely the fact that they are independent from the underlying sales contract, which has been repeatedly referred to by Professor Kuti in his papers. And to this effect, both the UCP 600, the Uniform Customs and Practice in Documentary Credits, the code, the most recent version of the code issued by the ICC, and the UCC, the Uniform Commercial Code of the US, and especially Article 4A and revised Article 5 respectively, have been on the same vein and supported the principle of autonomy emphatically. So particularly Article 4A of the UCP states that the credit by its nature is a separate transaction from the sales or other contract on which they may be based on, and the UCC, the revised Article 5, states that the rights and obligations of an issuer to a beneficiary under a letter are completely independent from its existence, from the performance or non-performance of a contract or arrangement out of which such letter has arisen. On the same basis seems to be the case law. For example, the case of United City Merchants versus the Royal Bank of Canada. It's a landmark case, of course, in the area and the principle of autonomy. Other cases, such as Hamze Himalas, are to the same effect. The courts in both cases have stated that when banks deal with documents, they shall only be concerned with documents, not goods, not services, not the performance of the documents which they relate to. So in any case, banks have neither the facilities nor the responsibility to verify facts which are outside the documents presented, such as the real physical state of the goods, the accuracy, the authenticity and genuineness of the same. That's something, that's something that Professor Goody has also referred to many times, and therefore my supervisors, Professor Atodo, argument also comes here. It is quite relevant because the detective agent argument kicks in. The bank shall always be prudent and exercise their examination duties with reasonable care and professionalism and due diligence, and they shall never be acting as a detective agent trying to verify or unravel qualities or characteristics that the bank is not aware of. Of course, there is here an argument I can refer to about red flags. Professors Ellinger and Dolan have quite often referred to those red flags arguments, and case law has referred to this argument sometimes. A case I remember is the J.H. Rayner versus Hambros Bank, in which case a bank being aware of any red flags, they would be not acting diligently if they do not take such red flags into account when examining whether the payment shall be, under the circumstances of the letter of credit, be honored. So it is, Yes, it's similarly important, though, to refer to arguments of overconfidence, arguments against over-relying on the principle of autonomy, since it has been criticized that over-relying on this principle is maybe the reason why the declining numbers of the letters of credit have been noticed. The last report, the last edition of the ICC on letters of credit shows a declining trend, and over-reliance on this particular principle is considered to one of the reasons about the decline, and there is that argument that banks shall not, however, be based on technicalities, and that unnecessary judicial dicta may embarrass business dealings in the future if based on such technicalities. So this argument supports a more flexible approach potentially, but the issue here is how far should that flexibility go in order not to place additional burden on the bank and jeopardize the bank's integrity, reliance, and trustworthiness, not only in relation to their customers, but also the other market players, if they simply rely on technicalities. One case where this matter of technicalities has been dealt with by the court was the Donald Scott and Barclays Bank. It was a case where this matter had been quite long analyzed there. So moving on to another vital principle governing both the letters of credit and the nature of the bank's obligations in general is irrevocability. Is it there is that question, is it a definite end to the revocability's low level of security? Because revocability was often giving rise to the possibility of the issuer, without notifying the parties, modifying or even withdrawing the credit, leaving the parties seeking performance of the bank's obligation to pay, namely the beneficiary, exposed to great risks. And the UCP Article 2 and 3, the current version of the UCP Article 2 and 3, have come to support the matter of irrevocability. And Article 3 states clearly and expressly that the credit is irrevocable, even if there is no indication to that effect. And that's a position which reflects the contemporary modern needs of traders and the banking world, and enhances for sure certainty and security and the confidence of people, commercial trade people, against letters of credit. Also, Article 2, when interpreting the term credit, itself provides that credit is any arrangement that is irrevocable and thereby constitutes a definite undertaking of the issuing bank to honor a complying presentation. Therefore, irrevocability, the express reference of the UCP to irrevocability, I can say that they define more than before, more than the previous versions of UCP, the extent of the nature and the extent and the nature of the bank's obligation, payment obligation. So we have already said that the documents shall be compliant with the terms of the credit in order for the bank to be able to effect payment. But the question is, against what standard shall the documents be compliant with the credit in order to have the payment effected? So the standard inevitably affects the findings of the findings required for effecting payment on the part of the bank. Throughout the years, the dominant position has been, of course, that the documents shall strictly on their face comply with the terms of the credit, although it has been raised by many commentators that minor discrepancies should be ignored in order not to have the purpose of the letters of credit defeated for the mere existence of certain discrepancies. The strict standard has sometimes been criticized also in relation to imperfect documents, which are whose defect is only visible just before the expiry of the credit, in which case rectification would not be a solution, would not be available. So in that case, it has been argued, it has been supported by certain commentators that a substantial standard instead of a strict compliance standard would potentially promote fairness in that case, in case of minor discrepancies. However, the issue here is that minor discrepancies being allowed would bring into the forefront the question of distinguishing trivial from material deviations, which would be potentially an unnecessary burden, extra burden on the bank. And that's where the bifurcated compliance standard kicks in. However, although the US courts have sometimes in limited times, as in Bank of Cochin case, supported that the adoption of such standard would make some room to the issuing bank to take comfort due to the assumption that such standard would be a looser one. The history of the documentary credits has shown that there has been no special recognition around this standard, compliance standard, and that it would not be actually an alternative to the strict compliance, which is the dominant one. So having established the background behind the nature of the stone on which the payment obligation of banks relies, it is also important to refer to this objective test, which is applied for interpreting the terms of the contract of the credit contract and the UCP, since it is vital for both traders and the banks to speak the same language. So this test invites the reasonable business person test, and the question is the parties' intentions shall be identified by reference to what a reasonable business person would have understood the parties to have intended by the language they have employed in the contract. And of course, in a reasonable business person objective test, ingredients would be, among others, the relevant background, which was reasonably available to the parties when the bargain was made, the business common sense, the legitimate expectations of the parties, and all those things. So moving on, it is also important to establish the reasonable care requirement in relation to placed upon the banks. That's one of the differences between the previous version of the UCP and the current version. The previous version was clear about the requirement, the obligation of the banks when examining the documents tendered for payment to exercise within this process and in the process of discharging their duties reasonable care and diligence. And the issue is that in the current version of the UCP, this requirement has been removed. However, the entire context and the spirit of the UCP and the intentions of the ICC would never make any room for the banks to avoid being obliged to carry out the task without professional and diligent manner. So on the sole basis that the same is no longer expressly referred to the UCP. One argument which I have found throughout my reading about the removal of the UCP's requirement for reasonable care was not to allow the parties to grab on that reasonable care and professional and diligent manner of examination, and inviting further costly litigation for banks. So the court seemed to have the same stance in relation to the requirement of reasonable care. They do still apply the old common law requirements established in Bass versus Bank of Australasia and other cases, confirming that rationale later on. Confirming again that although there is no indication or desire to place any unnecessary burden on the bank, once a bank accepts this duty, it is in fact bound to effectively and accurately discharge their duty to the protection of all concerned. That's something which was reaffirmed also in Giant Singh versus Bangtel Indoshin by the Privy Council on appeal of the Singaporean Supreme Court. So having said all this background in relation to the sources of law and how the nature of the obligation of the bank to pay has been established, we need to move on to the essential part of the entire research project, which is the exceptions to the payment obligation of the banks. So since we cannot elaborate enough on this presentation on these exceptions, it is I have considered that it is it is at least necessary to refer to the fact that these exceptions have quite often been considered as the thrombosis of international trade and the impregnability of documentary credits. So that is something I will be trying to identify and explain throughout my research, and what is in fact the purpose of exploring those potential recognized or not exceptions is to be able to furnish, if possible, legal excuses, proper legal excuses, or on legitimate basis for refusing to honor the payment under a letter of credit. We will be seeing that fraud has been recognized, has been the most recognized exception of all the others I am dealing with. It was firstly introduced in the United City Merchants case with the ex turpi causa maxim, fraud unravels all, by Lord Diplock. However, other exceptions, such as nullity, for example, is one of the exceptions which is not so much recognized by common law jurisdictions, the ones I will be referring to. And Singapore is the only jurisdiction where it has, where a good reference to nullity has been made after the beam technology case of 2002, I think. So nullity, for example, is something I will try to investigate more. And moving to the methodology I will be using throughout this study for the purpose of exploring the main research question will be theoretical, and within this spectrum I will engage with three particular kinds of analysis, which are doctrinal, normative, and comparative. Doctrinal analysis will allow me, I believe, to reconstruct the content of the applicable law, both primary, with reference to both primary material such as legislation, case law, documents of importance such as the ISBP, the UCP 600, the UCC, and other documents of European standing, and as well as secondary sources, journal articles, etc., whose contribution would be undoubtedly immense. So normative analysis will give me the opportunity to a systemic critical evaluation of the current position in place and the productive evaluation process leading potentially to certain proposals, which is the purpose of the project also. So comparative evaluation, which is the most important and most challenging, I can say, given the fact that my project will try to engage and compare various common law jurisdictions, such as the UK and the US, of course, but also Singapore, Hong Kong, Canada, Australia, in order to check the different approaches followed and the different theories, principles established in those jurisdictions, albeit the fact that all of them constitute common law jurisdictions, and that's the interesting part, I think, and that's what may create proposals, this comparative element across the different common law jurisdictions. So, of course, there are challenges throughout this process, and some of them have already been identified. For example, having just mentioned that many jurisdictions will be explored, one thing is whether I should limit or restrain my research to Anglo-American jurisdictions, or whether embracing all these jurisdictions, the common law jurisdictions of Singapore, Hong Kong, Canada, Australia, potentially some cases of South Africa and Malaysia I have seen already, would be a better idea. That's something I am working on throughout the reading, and also the particular point of view from which the topic will be dealt with, given that there are less touched areas on this topic, as I have already referred nullity, given the fact that valuable research has already been conducted by distinguished academics and the courts addressing parts of the topic throughout the years. So
we have 1 minute left. I'm very sorry to interrupt. 1 minute.
Yes, no worries. Yes, I'm just finishing. So one of the challenges is also to find those less touched areas which are of importance within the context of international trade transactions and the exceptions to the payment obligation of banks within the same context, in order for this piece of research, the final piece of research, to be contributing significantly to the entire area. So I think I am finished just now.
Well, thank you very much for an illuminating and well-considered presentation. It raised many, many fascinating insights into a very complex area. So without much ado, I would now invite Dr. Samantha to comment on your paper or presentation. Thank you.
Thank you, Patrick. It's great to see you again after such a long time. So thank you, Rafaella. It was a very interesting presentation, especially on a very technical issue of letters of credit. You went over the exceptions very well, especially the ones relating to illegality, nullity, fraud, and unconscionability. And you have discussed how the laws have evolved in certain jurisdictions. So my first suggestion would be that when we are talking about exceptions, there are two ways by which you can actually compare the exceptions. You can look at one particular jurisdiction, for example, Singapore, and look into all the 4 exceptions. And then again, you can look into the US and look into all the 4 exceptions and see how those exceptions are played out. Or you can take fraud and look at all the countries where fraud is an exception and how they have developed the jurisprudence and what are the identifying feature or important feature of one of those jurisdictions. I think the second option would be a better option, but again, have a chat with Ben, because this is the novelty of your research, the deep critical understanding of how each of these exceptions play out. So that's my first suggestion. My second suggestion would be to use more illustration and hypothesis when you build out your own framework. So in your presentations, I have found that you have referred to certain case laws, and then you have said, if things were a bit differently, then this would have happened. Try to take that idea a bit forward, improve that, and produce your own illustrations. That would be very helpful for the examiners to understand how you have added to the existing knowledge, or you have made the knowledge easier to understand. So illustrations or hypotheticals, that's my second suggestion. My third suggestion would be to use case analysis, not case law analysis, but like actual facts which have happened in some cases which are yet to be determined. For example, the largest fraud on letters of credit is the PNB fraud case, where somebody was importing diamonds. So PNB, Papa November Bravo, PNB fraud. If you just Google PNB fraud, is the largest letter of credit fraud. It's yet to be like brought before the court. One of the fugitives is currently in jail in London, and there are a lot of extradition requests going on. And as you know, unless the extradition is successful, the actual case is not going. The criminal case is not going to start. So please have a look at some of the well-known cases of letters of credit related fraud. Similarly, you'd find something related to unconscionability where because of the type of trade, the bank has that obligation to refuse that. So this difference, and I think you have referred to this, the difference between illegality and unconscionability is a very difficult question, because then we bring in questions of morality. Something which is unconscionable in one particular state might not be unconscionable in another state. How do we solve that? So that can be another of your, let's say, part of your research question. And again, as we know, international commercial law is very nebulous when we dig deep, and it is very difficult to say that this is the clear demarcation. But your research is going to show us the different approaches taken by different jurisdictions, and perhaps say that, okay, at least we know where the gray area is. So you can demarcate that gray area. My fourth suggestion would be focus more on impact. One of the common criticism of research in corporate law or commercial law is that we analyze law, but then we don't say what is the impact of our research, what is the actual change that is going to happen, because we work at levels which may not have direct impact on the day-to-day life of common people. Therefore, this is one common criticism which has been leveled in research relating to corporate law and commercial law, especially international commercial law. So I would suggest have some, spend at least 1,000 to 1,500 words towards the end of your thesis, perhaps in the conclusion, where you can focus on what is the impact of your research on actual commerce and trade. All right, so those are my suggestions. Again, wonderful presentation. Thank you.
Thank you very much. Thank you very much. They are very helpful comments. I hope for Rafaella. And are there any questions in the meantime? Very brief questions based on the comments that have been made. Are there any questions? They are very, very helpful. I think the impact part is fascinating, especially in this area where maybe your results will affect these documentary letters of credit. But yes, it's worth thinking about. Yes. So are there any questions? Of course, we can reserve questions for yes, there is one. There is Dr. Esther Gumbo. Yes. So you can go ahead.
Thank you for the lovely presentation. My comment is more on the challenges that you had highlighted. This is not really my area of expertise, but I note you had mentioned that one of the challenges is that leading experts or scholars have provided valuable research. I think I would either exclude that as a challenge or rephrase it, because then it sort of undermines the research gap that obviously you'd need to have, and it also undercuts the real value of a PhD, which is to add to existing works, like your own contribution. So I think that aspect should actually encourage you to see what is already out there and where is that research gap actually positioned, and then you leverage that. Just what I'd say that in the general way. Thank you.
Oh, thank you. Thank you. Yes. So we have Gabriel next. Yes.
Okay. Thank you, Dr. Patrick. Thank you very much. First of all, congratulations, Rafaella, for a wonderful presentation. And like it has been said here, letters of credit is an instrument actually that is very complex. And in terms of looking at the legal basis, behind it and its operation, it's a very technical area. So for unpacking the whole stuff to all of us, it's a wonderful presentation. I think that your presentation is interesting from the point of view of the fact that you are looking at different jurisdictions, especially how these jurisdictions impact on the idea of the obligation, the payment obligation, as well as the principle of autonomy and the exceptions to this principle. I want to make a comment, first of all, with regards to the originality of your research. Even though this is a complex area, it is also an area that so many scholars have written on. I speak in particular reference to the issue of fraud and the exceptions to the fraud, to fraud in letters of credit. Now, think about, there are so many scholars, and even the cases. There is this English case, which I guess it was because of time that you couldn't mention it, the Montrose case, where the English court considered the nullity exception as an exception to the fraud exception. In that case, the English court took time to, balance the arguments for and against considering nullity in English law as one of the exceptions to letters of credit. And so many scholars have tried to look at both sides of the divide. Perhaps if you're able to read through all these analyses, then it will help you to bring out your own originality, because as it is, it may be difficult for somebody to answer the question what it is you are bringing to the table as a scholar, in this whole heritage of research concerning fraud and the exceptions to the fraud exception. So that's the first one I want to say. Then the topic says something about Anglo-American tradition, Anglo-American law. And so I remember that at the end of your presentation, you said something about finding it difficult to look at different under jurisdictions. So what I'm suggesting is, if you want to look at other jurisdictions, it is fine, but you make sure that the topic as well will reflect it. So that if you limit the scope in the topic, then extending would demand some justification from you. So I will leave. I have 2 or 3 questions for you, but I will leave that to. But I just want to say congratulations and well done for a good presentation. And
yes. Well, thank you very much. Thank you very much. I think you are getting very helpful comments from people who really work in the area. So that's very helpful. So without much ado, the discussion is open to the floor. And so if you have questions, that would be very helpful if you can direct them to Rafaella. So Gabriel, you had a question in the first place, so you can go ahead.
So I think it's better for me to continue with my questions. It's not a question you must answer at this time, but it's something that could help you, as you do your research. Recently, there are regulations, that have come out for the banks to be careful in considering these trade transactions and even letter of credit transactions, to look at red flags, which you mentioned, but these are red flags in accordance with the regulations as regards trade-based money laundering and terrorist financing in the underlying contract between the international buyers and the international sellers. What this means is that sometimes this may demand that the bank may have to look beyond the document to look at the fact, and this is against the principle of autonomy. So how do you look at regulatory compliance vis-a-vis remaining obedient to the principle of autonomy? Do you think that regulatory compliance will vitiate the demands of the principle of autonomy, or do you think that there is a way that you can balance 2 of them together? Then the second question, you did mention that letters of credit, as an instrument of trade financing, is actually, in terms of its popularity, the popularity is getting down every day. And you mentioned some of the causes of the plummeting phenomenon of letters of credit. But the truth about it is that a lot of people are no longer comfortable with the paper-based nature of the documents that are presented, in letters of credit transactions. You might know that in the UK last year, an act was enacted. That act was the Electronic Trade Documents Act. So that particular act makes it possible for us to now transact with electronic bills of lading, at least within the UK. Now, if you think about it and think about the possibilities of digital technology, you will see that in the future, it might be possible for beneficiaries to present documents and for banks to examine these documents without having any physical or manual relationship with the document. It will be about digital. This can be done on a blockchain platform digitally. Okay. Now, increasingly, scholars are arguing that if this is possible, that the divide between data and facts is closing, because it's possible now, because the whole principle of autonomy is built on the fact that there is a divide between document and facts behind the document. And the emphasis is look on the document, don't look on the facts. But if we move to the digital platform, there could be the possibility that there could be what I call a merger between data and the facts behind data, with the use of artificial intelligence and with the use of smart contracts. In such a situation, maybe it will be interesting to your own research to think about how the principle of autonomy will fare in a digital regime. So that's just one of the contributions I think might make your work novel in this area.
Oh, thank you very much. Thank you. Thank you. Is there anyone else who wants to chip in? So I have a standard question, which one usually raises in these circumstances. How will your thesis differ from what has gone before you? So you were referring earlier at the very beginning that there is an extensive literature on letters of credit and all the like, and your supervisor actually wrote a book on it. So how will your own research differ from what has gone before?
That's what I was referring to. I think in the challenges of the topic, and that's I think that was something that Professor Samantha tried to assist with his comments now. I think that what will be different shall be the point of view, the angle from which the comparison in brackets will be made in the effort to contribute to the area, especially in the less attached areas of the whole international trade financing system. I think that the way in which Professor Samantha has proposed that the research shall be made is one of the factors that may contribute to this original way of addressing the topic, and also the fact that I aim to address less touched areas and compare with jurisdictions that may have not been in which these less touched areas, such as nullity, for example, have not been explored. So I think that we all have the same basis. We know that, but I think that I will try to add something on those areas which have not been developed, for example, with reference to jurisdictions such as Australia, Hong Kong, Canada, in relation to exceptions which have not been so well recognized across the jurisdictions I am dealing with, such as nullity or unconscionability, and also the difference between unconscionability and illegality may be something which Professor Samantha again referred to, maybe also something I should build on. for
Yes.
promoting this originality. Yes.
Yes, that's very good. But you have to be very careful about even comparing some common law countries, because you were referring earlier to South Africa, but it uses a hybrid legal system, which is not
Yes.
entirely based on the English one. So it is based on the Roman Dutch system. But
Yes.
unless perhaps in
And
this area
Malaysia
there
as
are
well.
obvious similarities, then I think one has to be very careful. So it's just a general comment.
Yes.
Are there
Thank you
other
very much.
questions from the audience or comments? So I think I will ask another question. I will take advantage of the silence. So you were referring to the comparative nature of the project. Do you foresee any obvious difficulties with comparing the laws of so many countries, apart from
Yes.
what I have just referred to in relation to South Africa?
Yes, I think that at this stage, where now we have started exploring the exceptions one by one. So I think that during the following months, it will be easier to address this question in my mind as well, because seeing how the legal system of each of these jurisdictions deal with each of these exceptions, and whether there are similar, the ways they are dealing with them are similar or quite different, will help me understand whether it is feasible and it is workable to engage all of these jurisdictions in my research. That's because I put that in the challenges, because I am not certain yet if I should include all of them or whether I should be restricted on Anglo-American jurisdictions. Yes.
But even that restriction, I think, is bound to give rise to a lot of complexities. Perhaps
Yes.
maybe you could look at a specific country, and then maybe if you are criticizing what happens there, you could rely on what happens elsewhere. So you are just really introducing what happens elsewhere in a limited way, because if we were to look at all the Anglo-American jurisdictions, I think it would be a very complex task, which would require years. So it's just a general comment, but if it's for you and your supervisor, but I just foresee a whole host of cases to look at and other materials, but that's what you can look at. It's just a general comment. You don't have to take it on board. Yes. So I think we have a comment from Navajyoti.
I just wanted to take one of the points which Patrick has just mentioned about how to compare across multiple jurisdictions, especially in comparative law. So I would, again, there are two main ways of doing it. If you want to compare more than, let's say, 6 or 7 jurisdictions. One is the quantitative way. If you read the papers by LLSV, what they do on corporate governance, they compare like 50 different jurisdictions. So most famous of their papers is Law and Finance by LLSV. If you search, it has like over 30,000 citations. The other one is by using a particular story and then asking scholars from that particular jurisdiction as to what is going to happen if this story plays out in your jurisdiction. So if you read this book by Gabriel and Sims, they have a book on how to do comparative analysis based on using a case study method. So Matthias Sims, he is one of the scholars who writes a lot in this area. So if you're going to compare more than 5 or 6 jurisdictions, you have to pick one of these methods, either the quantitative method by LLSV or the case study method by Gabriel and Sims. I have a book by Gabriel, but I think it's downstairs. If you're interested, drop me an email. I'll send you the name of the book. Thank you.
Yes, I would love to. I want
drop
to.
Me an email.
Yes, thank you.
Well, I guess it has been a very fascinating presentation. It generated numerous questions, but unfortunately, time is not on our side. Yes, and of course, thank you very much, Rafaella, for a very stimulating presentation, and I wish you the best luck in your journey, and hopefully you do very well, and this will have an impact. So same day, same time next week, let's meet our next guest speaker, John E.K., PhD candidate, School of Criminology, University of Leicester, who will present their project on colonialism, socioeconomic status, and alcohol abuse, understanding the mental health of prison inmates in Nigeria. And the presentation will be held next Wednesday, 6 November 2024, between 1500 and 1600 hours. So look after yourself until then. Have a great day and see you next week. Thank you very much.
Thank you. Thank you all. Thank you very much for all the comments. They were really useful. So thank you so much.
Thank you. Thank you. Nice to see everyone. Thank you.
Thank you. Bye.